Yes, and
You and me.
talking about relationships.
We can talk over each other, and that would be inappropriate. You're going to keep speaking over me? You seem to be a very aggressive, controlling kind of person, but
This case explodes from the very first second. A defendant accused of serious crimes caught texting a key witness offering compensation. But was it money? Was it manipulation? Or was it something even more calculated? The judge isn't buying the selfless hero act, especially when prior felony convictions enter the conversation. And just wait until you hear what happens when the court starts talking about witness tampering and 25 to life exposure. The tension in this courtroom is thick, and the stakes, they couldn't be higher.
So, what has been,
that's a yes or no.
yes.
Then he can ask this next one.
Did you ask her to lie or tell an untruth at any time?
No, sir.
There's been talk about your offer to compensate her. Was that for the letter or for something else?
That was, for the letter, but the compensation was that I would still be there for her whenever she needed me, because she had just, called me, and I helped her in the last 3 weeks prior, because her son, I had no contact with her since March. And so she called me and, distraught because her son had a heart attack, and if I'd be there for her. And I said, sure. And so compassionately I did. And, I gave her money for snacks up there at the hospital, so on and so forth, brought her food. And then afterwards, she said, well, what can I do for you? And I said, well, I need some help. I need you to help me out and be a witness, because you know what was in the back of my truck. And I said, I told her, in not so many words through the text messages, that I would compensate her, which meant I would still be her person, which is in that text messages. It had nothing to do with monetary value.
Did you subsequently, after breaking up with Miss Griffin, get married?
Yes, I did. And I told her I was getting married in November. She tried to call me back to get back with her on the November 24th. I told her there was no way. Too much water under the bridge, too much control, too much trying to just keep me wore down, control. And enough was enough. And I went on to better my life.
So it's it's her fault.
Sir?
It's her fault.
I was I was so controlled that when I was getting my Class A CDL in February, 2 weeks before I went to take my test, she begged me not to take the test, and that she would give me $400 out of each one of her paychecks if I would just take the job that I got, because that way she could continue with the trackers on my truck, and there's no trackers on an 18-wheeler at my job. So therefore, she didn't want me to go anywhere. And I said I couldn't do it anymore. That I want to work. I've been a Boilermaker all my life, and I wanted to work, and I wanted to advance in this company. And I got my Class A CDL. And the day I got my Class A CDL, she left before I even got home from Longview from taking my test. And then there was nothing from March until June. He had a heart attack. She called me out of the blue. I'd be there for her. I said yes. And that was it. And I did not ask for any compensation as far as monetary value to get the letter. She said that she would gladly. And she wrote the letter. I have the letter. I gave it to Mr. Megan. I did not crumple it up, and I did not shoot the finger at her, what she said. It's intact. And there's no pieces from being crumpled up. Since then, she has called and tried to sabotage our relationship. My wife has the text messages, and I've asked her to leave us alone. She knows we got married, and this is why she's doing what she's doing.
Hold on. I'm a little confused here. This State's Exhibit 1 that's been introduced, these are your statements, right?
Yes, sir. I don't deny any of
Okay.
it. It's just that I did.
Mary, please, are you going to help me or not? Everything else is frivolous. Sounds like whether she helps you or not is of primary importance to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate your helping me. You don't have to. That's why I'm going to compensate. That's the only thing we're dealing with right now.
Yes, there was
That's
phone
pretty
calls.
insistent.
There was phone calls in between the text messages, and we was talking, and then I would, and then she would get mad and hang up. But in those phone calls,
Well, hold on. I'm just fuzzy. What is it that you need her help with? Since everything else in the world, in your life, and the existence on this planet is frivolous, other than that primary need of yours. What is this primary need?
so that phone call consisted of
What is your primary need that you're expressing in words here? You're going, please, are you going to help me or not? Everything else is frivolous. This is the most important thing right
Yes.
now in existence in the universe. What is this most important thing?
She asked how she could help, and
No, what is this important thing
Help.
that she, of what, sir? You're dancing around this issue. Helping you what?
helping me with this case because
This case.
she knows I was innocent. She knows I was innocent.
I would compensate your helping me.
Yes, by being her person, and I have that in the text message. I will which means I will, anytime that anything goes wrong in her life and she needs me, I will be there. She always called me her person. Even the day she called and her son had a heart attack, I said, "Why you call me?" She said, "Because you're my person."
Yeah, I know you're making this sound so selfless on your part, but you say, are you going to help me or not? Everything else is frivolous.
Yes,
It's your need.
talking about relationship.
We can talk over each other, and that would be inappropriate. You're going to keep speaking over me? Let me speak, then you can speak. Number one, it's rude not to, but number two, she has to take all of this down, and she can't take with two people to take it down.
Yes.
And you seem to be a very aggressive, controlling kind of person, but relax. Okay? You'll get your chance to be heard. Are you going to help me or not? Everything else is frivolous. That's pretty succinct. This is whatever this is that your needs are. If this is your need, it's more important than anything else in the universe, according to you. What you do is none of my business. That's why I don't ask, and vice versa. I told you I would compensate you helping me.
Let's pause right here because this is the turning point. When a defendant says he's going to compensate a witness who could help him in a criminal case, that sets off serious legal alarms. Under Texas law, offering any benefit to influence testimony can qualify as witness tampering, even if the benefit isn't cash. The judge is drilling down because intent matters. If you're trying to shape testimony, that's not support, that's obstruction. And notice how the defendant keeps reframing compensation as emotional support or being her person. But here's the question. Why use the word compensate at all? If you were innocent and simply asking for truthful testimony, would you phrase it that way? Or does that wording reveal something deeper? Drop your thoughts below. Is this poor wording or something more strategic?
That's the only thing we're dealing with. You're talking about compensating her to help you in this case.
Yes, sir.
You see anything wrong with that? Because when somebody is a witness that may help you, you have a right to get that. And they're subpoenaed and they come under oath, and based upon the sanctions that perjury can bring about, people better tell the truth. They don't get paid for being a witness generally. But what is it you're paying her to say?
I never offered to pay her. I always said,
Wait. That's what I would compensate your helping me. Didn't you say that? There it is.
and I didn't mean it monetarily. She talked about,
Wait. What compensation are you talking about?
in return, my compensation would be to help her anytime she needed me,
Oh.
as I did
Oh,
with her son.
just being a wonderful guy.
And that was, yes, and I was.
Okay. Well, no, sir. You've been convicted of felonies twice. That's a character issue. Haven't you? I'm sorry. That's what the grand jury says, that you were convicted of burglary of a building, which is similar to what you're charged with, your burglary of a habitation.
Well,
And then, hold on, and then sexual assault of a child. You were convicted of that, weren't you?
and
Do you find that, is that true?
yes, sir,
Isn't that serious?
it's very serious.
Okay, all right, all right.
But by the second, can I say something?
Yes.
By the same token, on each one of those cases, it was a finger point, and my lawyer's done nothing. Wright Kimler, I sat right there in Walker's court, and Wright Kimler denied me and my 5 witnesses to testify, then straight up denied me.
So it's somebody else's fault.
Well, I was begging.
No,
to
is that
testify.
yes or no? It's somebody else's fault.
It was Wright's fault.
Okay.
Or it was my fault because I didn't get a better lawyer. I didn't know how to get a
Okay,
lawyer.
but it was somebody who didn't do their job. But you have been convicted twice on two separate serious offenses, and you're saying that wasn't your fault.
No, sir. It wasn't.
Is that right?
I didn't get my day in court.
Sir, were you found guilty? You have a right to appeal. Did you appeal those cases?
Yes, sir.
And what were the results of the appeals? They were affirmed, weren't they?
No, sir. Brian Lane's still working on my.
No, sir. Have they been overturned?
I'm working on it.
Sir, until they are overturned,
Yes, sir.
a conviction is valid
Yes, sir.
unless it's overturned.
Yes, sir.
I'd like to see the future that you're looking into, but and we're talking about a conviction. First of all, in 1989, that's 30 some odd years ago, 37 years ago. And, that appeal is way out of time. So the only thing you would have would be a writ of habeas corpus. Is that what's being done?
I didn't try it. No, sir. It was
So you're not appealing that case?
no, sir.
That's what I thought you inferred to us a little while ago.
No, sir.
All right. Then the next one is 2005. That was over 20 years ago.
Yes.
You don't have much of an appeal at this time. You may have a writ, but an appeal is way overdue.
No, I started the appeal in 2018, 2 years after I got out, and
That was-
I wanted to get it.
Okay, isn't that 8 years ago?
Yes, sir.
Okay, what's the result of it?
I don't know what's happening. Yeah, I
Oh,
was down Brian Lane.
Look, a conviction is valid unless it's overturned. Unless that happens, you can sit there all day long and cry foul, but it's the way it is. But you have 2 convictions,
Yes, sir.
and they make up part of this case and its punishment, which subjects you to 25 to life. Anyway, we can beat this one a while, but State's Exhibit 1, which is part of the record, clearly states, and you've made it clear, that you're referring to this case and you're willing to compensate her for help in this case, and that seems pretty clear.
Sure.
What else do you want to ask?
Questions from me?
The only thing I want to ask you in regards to just this issue, I've got plenty other things I'd like to talk about, but I want to know if you're going to admit that you texted her January 26th of 2026.
A week ago?
Yeah, just a week ago, after you found out about this motion, did you in fact engage in text that lady right after, just like she testified?
I had no idea.
Yes or no?
Yes, but I had no idea she made the complaint. I had no idea. I didn't know who this was. You can ask my lawyer. I had no idea.
You're going to tell me that this
Well,
lady,
let him finish, please. Go ahead.
I had no idea. Yes, I've come to him, and we thought this whole time it was another woman named Denise that stole $10,000 from her, my wife. I had no idea that it was this person at all.
so it's just ironic that the same day that you talked to him is when you reached out to her.
I reached out to her because I got a letter in the mail that was opened already and on the ground, and it said municipal court in Nederland. And I simply asked if she had a ticket that I'd help her with it.
I don't have any other questions.
With all your troubles, with all these fires, these raging fires that are occurring right now, you were worrying about her traffic, some municipal ticket. That's what you were spending your time on? Is that right? When you have all of this, looking at 25 to life, you're saying you stopped what you were doing and were curious about whether she had a municipal city ordinance ticket?
That's what she failed to, it's on the text message that she failed to
Okay.
provide that. Yes.
Anything else?
Mr. Porter, are you employed? Are you employed?
Yes, sir.
And whatever conditions the judge imposes on a bond, you'll follow those, right?
Yes, sir.
And you'll show up in court when you're supposed to,
Yes, sir.
if nothing further on.
All right. Go ahead. Anything else to add?
No, Judge, you've
Gotcha,
covered
gotcha.
a lot of what I wanted to do, so in the nature of time, I'm going to pass.
Summarize. What do you have? What relief are you asking? And then Mr. Macon, what you respond to. Go ahead.
Judge, based upon the testimony from both witnesses today, I'm not convinced that there's a bond amount or conditions that can guarantee the safety of, one, the witness that just testified, and two, the community in general. In that regard, based upon the motion to increase, I ask that Your Honor revoke the bond, which in my opinion was insufficient, and let's leave him waiting trial.
Go
But
ahead.
as for no bond.
Go ahead, Mr. Macon.
You know, we would naturally disagree. We think any bond Mr. Porter made, he would do. He would not contact anyone. He doesn't represent a danger to the community. He's employed.
All right. What is his bond right now?
30,000, you know.
Okay. The court is going to keep you on a bond. Your bond, though, is doubled to $60,000. And you must have a GPS device at all times. Do you have one on you right now? You must have a global positioning device so I know where you are at all times. And you shall have, as a condition of bond, no contact with any witnesses in this case except through your attorney, Mr. Macon. And you can, of course, contact your own witnesses directly, but not witnesses who may be witnesses for the state. And we know that this lady was a witness for the state. Section 36.05 of the Texas Penal Code provides for felony punishment for any person who, with intent to influence a witness, offers, confers, or agrees to confer any benefit or of a witness or prospective witness in any official proceeding to testify falsely. Sir, it's clear.
This hearing wasn't about guilt or innocence. It was about bond conditions and witness integrity. The court examined whether the defendant attempted to influence testimony and whether his prior felony convictions increased the risk to the community. The judge doubled the bond to $60,000, imposed GPS monitoring, prohibited contact with state witnesses, and even referred the matter for possible grand jury review regarding witness tampering. That's significant. When a judge mentions potential new felony exposure under Texas Penal Code 36.05, the stakes escalate dramatically. Now the defendant isn't just fighting the original charge, he could be facing additional legal jeopardy. The broader lesson here? Words matter. Text messages matter. And when you're under indictment, every action is scrutinized through the lens of intent. If you found this case as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments. Was this manipulation or misunderstanding? And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
According to Hurrett's testimony, that's what this is all about. And I'm going to ask the state of Texas to refer this also to consideration for a grand jury review. The commission of the elements of a crime constitute a violation of that bond. If this court discovers any further failings to follow bond conditions, then we'll bring you right back up here, and then it will your bond will geometrically increase, or it will be disallowed completely, and you'll have to be in custody until such time we have this trial. Are you setting this thing for trial?
Yes, sir.
It is on the trial.
Let's get it done. And I don't want to hear anything about attempts to influence witnesses. Work through your attorney. He knows how to do things.